Well, let's call this meeting to order. First of all, my name is Kay Leach, and I'm serving as the chair for the Monroe County Board of Health. And I'll introduce the other board members that serve with me. First of all, we have Ashley Cranner. Ashley, you want to give a wave so people know who you are? Then we have George Hageman. George. Then we have Mark Norrell. Mark. 2 thumbs up from Mark. And we have Dr. Steve Pritchard. Steve. And we have Dr. Carol Talukian and Dr. Robert Wren. Okay, that's who we are. And also I want to introduce our administrator for the Monroe County Health Department, Penny Caudle. Penny is right, we can see you. And our health officer, Dr. Sharp. Dr. Sharp, can you kind of peep in the screen for us? And let's
There
see.
you go.
There he is.
There you go. Look up.
Right here.
Hi, Dr. Sharp.
Hello.
And also we have our legal representative with us today, Margie Rice. Hi, Margie. Okay, first of all on our agenda is public comment. We always, before a board meeting, give the public the opportunity to bring any issues they'd like before the board. If you have a comment that you'd like to make, please raise your hand at the bottom of the screen and we'll recognize you. Any public comments out there? I don't see any. Does anybody else see anyone raise their hand? Okay, none coming forth, then we'll move on the agenda. Next is the approval of our June 20th and August 3rd meeting minutes. Let's start with June 20th. Did everybody have a chance to read the minutes? Any corrections? Okay, how about August 3rd? Did you have an opportunity to go over those? Any corrections? Do I hear any motions?
I move we accept both of them as written.
I'll second.
I have a motion and a second, so the minutes will be accepted as written. Okay, next on our agenda is variance request. Is there anyone here that's going to speak to that issue?
I will start and then I'll kind of let Margie, and then there may be some others that want to speak to that. So we did have a variance request for a septic that is on less than an acre of land. The permit was denied based on the code. The request was received, and then you have the follow-up from legal department recommending that as a health board, you do not have the authority to make that accept that variance. Margie can say this much better than I can. The commissioners in the code did not make for that allowance.
Yeah, and I can speak to that as well. You all should have received a staff report and recommendation from me where I cited the code and the provision. And we've also got, I see on the call, we have AJ Bolin and Margie Everly-Pauley, who are the real estate agents involved in this transaction, one for the buyer and one for the seller. I've had the chance to talk with both of them as well, and have I think they've both seen my staff recommendation report. So I'm happy to answer any questions you might have about it, but I tried to give as much background information as possible. I will say, I think the last time you guys have had a variance request was in 2013, and that was denied. And I don't know that this board has granted variances on septic permits in the past. Penny, you may have more of a history than I have on that.
Yeah, we have not done one. As I said, I think we had to look back. We had a request in 2013. Way back in the past, there were lots of variance requests, but with the changes, they have not been, there have not been many requests or many granted in recent times.
Okay,
This is Mr. Baker, the property owner. And I would like to understand some of the definitions and the criteria. We did receive the individuals who put forth for the variance did receive indication from the health department that if the property was platted before 1993, then that property was available to be able to get a septic permit. Based on what I'm hearing from the attorney, it doesn't seem that that's the case. As a person who purchased the property in 1991 as a single family piece of property that had water run to it, that had phone run to it, that was part of a 12 parcel plat that was put forward by Herschel Hartsock and his wife. This was property that was intended at the time to be residential housing. There are 6 other homes that have been put on these 12 platted pieces of property. And based on the information that I have and that I received at the time, it was indicated that they're trying to get Botus, the seller, indicated to me that there was a septic permit on it. Again, she just indicated to me, I don't have any record of that. I thought that the health department might have record of septic permits that were pulled over the years. Again, this has been 30 years ago that we purchased the property. But I felt like, given that the property was platted, that it was single family, we have been paying property taxes on it that are quite high for a piece of property that is not buildable. We're paying on a $30,000 assessment for a half acre, which is a quite extensive amount of money for a piece of property that would not be buildable. So I'm just trying to understand how we buy a piece of property that we feel is buildable. I understand that the health department is trying to improve the quality of the water at the lake, but I feel like there should be something for homeowners or for property owners that purchase property that was platted and was single family to maintain that. Seems like there's, the switch in policies from the time it was originally platted to the time we purchased to today have rendered the property pretty much just a vacant piece of property based on what I'm hearing. And I don't quite understand how that can take place. Also, is the portion that was put in the letter to the individuals who put the request in, that there is a variance, and I can read the language as it's stated. It says individual lots and subdivisions to utilize on-site sewage disposal systems for which plats were approved by the local planning commission or recorded prior to September 1st, 1993 are exempt from the provision. Is that correct?
Margie, do
Yes,
you want to?
yes. Yes, are you talking about Monroe County Code 365? Is that what you're referencing?
Yes, yeah. Yeah, 365-4A, it looks like.
Right. Yeah, so, and if I could, if TSD could let me share my screen, I want to show you. And again, I think, let me see if I can share my screen real quick. Zoom. Could TSD enable the share screen feature for me? says it's the host is disabled, the participant screen sharing. Let's see if that,
Be able to
okay.
share now.
Thank you very much. Appreciate that. Hold on. 1 second. So here, if you see, I've got the GIS pulled up. This is the Thomas Baker, Mandy Tooley form. And if I pull this up, let's make sure you see this. Are you seeing this screen here?
We
Yep.
did see a plot and now we're
Yeah,
just,
yeah. And so this, you can see that it says this is vacant, unplatted land. So the address, the owner address is Whiteland. The property address is East North Shore Drive, Unionville, vacant, unplatted land. It's my understanding that this is not one of the grandfathered, it was not a platted lot. And I kind of, and I will stop sharing at this point. You can see here, this is just the GIS record that they are being assessed 30,800. That is higher than some of the parcels. I think two parcels over, there are 2 half-acre lots. Each are being assessed about 2,600. I don't know, Mr. Baker, if you've ever done a property tax appeal to the assessor or not. That's certainly something you'd be entitled to do when you get your notice of your assessed valuation. You could always, at any year in which you get a notice of AV, any property owner can go to the assessor and say, hey, I think I'm being assessed too much, and
So,
start that
yeah,
conversation.
Thank you for sharing that. So does the paper documentation at the courthouse supersede the electronic record that you're displaying?
It does. And I did a little bit of research. So yes, you're not allowed, really to rely upon GIS for,
That's what I
say, a
thought.
title search. But I did go back, and Ryan Casper Cushman, who's the wastewater sanitarian on this case, he and I looked back, and I had a great conversation as well with Margie Everly Polly, who knows this history of this lake better than probably anybody else on this call, it sounds like. And it's my understanding that this lot never was platted. It was not part of a platted subdivision, that there was not a septic permit. Now, she thought, maybe we ought to look back at our records. I'm told from Ryan that our records back, beyond, say, the, 70s are a little sketchy. So what I would suggest, it may be that maybe a septic permit was at one point granted for this property and we just don't know about it. I haven't found it. Ryan hasn't found it. I don't believe that a structure was ever on this property. There are a couple examples that I went through on my in my memo. There were a couple of other lots where they were smaller than an acre, where there was an existing structure, and the health department allowed a repair permit in order to improve the system and put a functioning septic there. And this one, I don't think has ever had a house on it. I don't think any of the houses sort of east of the, what I think is the Thompson property, have ever had structures on them. I think they've always been vacant.
No, they haven't. There was a trailer that sat at the very end of the property for an extended period of time.
And one of the things I had, pardon?
I do have paperwork where it was actually recorded that it was 1980 that this was recorded, that this property was platted. A portion of said quarter section into 12 lots, legal description of each lot and plat thereof being exhibited. So
do you have a document number on that by any chance?
Yeah, I have a book number of 280, page 65. There's a document number of 125, 330, if that's the number that's stamped on the top left.
Mm-hmm. Is there, yeah, book number 288, page 65. What's the date of that?
The date of this document was 1980. December 20, dated 22 of December 1980. And this is part of the easement documentation that went along with the property.
So one of the things that Margie Everly Polly and I talked about was perhaps, I don't know, again, Ryan and I did not see that there was ever a septic permit granted for this property such that a repair permit could be upgraded. But it may be worthwhile for the agents and Ryan, and I mentioned it to Dave Schilling in my office, who handles planning issues, see if we could sit down and see if this, if there's a way forward. Again, what I've seen, the history of the properties out there at the lake is that only the properties that have had an existing system or existing house are the ones that have been grandfathered and given a repair permit. And again, obviously, if there's a plat that grandfathered it, that'd be a different story. And then otherwise, property owners have had to, congregate land to make it big enough to put a septic on or get an easement from a neighbor. Now, there does appear to be, existing properties around this one where maybe an easement could be negotiated for a neighbor to allow a septic on that property. And that's happened elsewhere on the lake. But given Monroe County's slope, Monroe County's clay soils, and this, heading straight into a water source where people play, the county commissioners took a pretty conservative approach, and it's very common though across the state of Indiana in lake areas to require, and especially where we have the kind of soils that we have here, and the slopes, to require a minimum of 1 acre. So
I believe that all the assessments have been done because the Board of Health asked them to continue with the process to address all the questions. I don't believe there's anything wrong with the soil, the slope, the number of potential sites they can put a septic system, which are 3 sites on that piece of property. The perk test was fine. The only challenge to being able to put a house on this property was an ordinance that was put in place well after we purchased the property, thus making the property unbuildable. So that's my biggest challenge. I mean, I understand that if somebody comes forward today and tries to break it out into half-acre lots or quarter-acre lots and try to put a septic system on it, that you have every right to say that, we're trying to clean things up. But for somebody who's purchased a piece of property in good faith that it appears was platted based on the documentation we have, that was put forward as a residential piece of property, it's really troubling to think that, they can take a property that is now valued at $100,000 and make it worth about $5,000.
2,600.
So it's just a bit of a kick in the gut for somebody who's a homeowner or not a homeowner, a property owner in that county to find this out. So
I will say that the AV, just keep in mind, the AV is only 30,000. Not that the assessor's values aren't low, which a lot of people.
we have an
it's
signed offer for $100,000.
Yeah, a lot. I know. I get that a lot with the assessor, and she's always like, say thank you, because your taxes are based on a lot lower than 100,000, 30,000 for this one. I think the ones next door are for sale for a couple $100,000, and she has 2,600 on each one. But I'm certainly happy to look into that, and I was going to see. I don't know if anybody else, I know Margie or AJ have comments that they want to make, or Penny. Is Ryan on this call, Penny?
Can the buyer make a comment?
Sure.
Yeah, since it's my since it's my appeal.
Sure.
Thank you, Mr. Baker. I thought that was well put. My appeal is simply to utilize the engineering best practices concepts of risk mitigation in an effort to reassure you that no matter what justification you use, be it legal or historical, to approve this permit, there's little or no risk that sewage will flow to Lake Lemon. That's the core of my appeal, and let me continue. Can I go ahead and get shared my screen? Because this is going to go, I don't have much to say, but this is going to go audio visual, if you will.
Sure. And
By way
I will
of-
say, real quick, Ryan Casper-Cushman is on this call. I don't know if he needs to be elevated to a panelist so that he can speak, but
That'd be fine.
if TSD can elevate him, and then we can hear from the buyer.
Can I share my screen?
Yes, TSD, can you allow him to share his screen?
Figure out how. Oh, there it is. All right, so by way of background, I'm an engineer with 39 years experience in the aerospace industry, working with NASA, the offshore oil industry, human-occupied pressure vessels and submarines, human-carrying devices, including cranes, roller coasters, and even human-carrying robots. Every one of these developments involves an assessment of safety and risk, and the processes provide the designer clear analysis procedures and methods to mitigate risk through best practices in design, build, and qualification, and finally through redundancy when it cannot be completely eliminated by design. I'm asking the board to evaluate this very unique plot and the proposed septic system on its merit and on the minimal risk it poses. The buildable portion of this lot is on a plateau, and let me show you what that means. If I can get this to fly around. Can you all see that? The white thing is the buildable, is the lot. The buildable portion is up on the top. It's at 795 feet, some 165 feet in elevation above Lake Lemon, which sits at 630 feet at the spillway. Further, the lot borders on Lake Lemon Conservatory District. All of this land in here is Conservatory District, putting the house and septic system 450 feet. So if the house is here, there's 450 horizontal feet from the water. This system will not flood over when the lake rises like many on the lake. There's septic systems down here that when the lake rises, you got problems. The proposed Presby system, which when designed, approved, installed, and inspected properly per the code, will last 30 years. This board's process should also evaluate the soils report. I encourage you to do so rather than taking, saying, oh, it's all clay. Further, when you look at the topology of the lot, and if you look at that picture that Margie brought up, the highest point of the lot is here in the front of the lot, in the buildable portion of the lot. It will be installed on the, the east side, and it slopes this way. It slopes toward the north. And it slopes away from the lake. So anything put in the Presby that may overflow flows away from the lake. The flow line from this system has to go all the way. Can you guys see my hand? It flows all the way down and goes into this gully. It flows all the way down, and somehow it goes into probably an underground stream that goes into the lake. That's a 1/4 mile long flow stream. Any kind of overflow is not making it to the lake. This is a very unique situation. A simple visit to the lot will bear this out. We also meet the requirements for space for 2 systems should the first fail and require repair. Although it's only 0.52 acres with the house in one point, I point you to the one that Margie, it's in the variance request. The Presby system, as it stands, you can still put an equally sized Presby system parallel to the road, in a repair after 30 years. Further, the concept of buying another 1/2 acre or obtaining an easement will alleviate the risk is flawed unless that extra land will materially provide a barrier between the risk of leakage and the lake. The code's language does not provide the requirement for this analysis. If I bought a lot that's west of this lake, it wouldn't help. It's kind of a ridiculous rule. That's why the board is asked to look at each application and evaluate each lot and use logic and risk analysis to make its decision. I appeal to this board to analyze the risk of approving a septic system on this lot on the basis of an analysis of this particular unique location, topology, soils analysis, proposed design, and finally with the confidence that they have met their duty to protect the citizens of Monroe County and its resources. Thank you.
And if I can, I just want to point out, I think that the board certainly can table this and give us a little time to look at more, the information, especially to see if this is a platted lot based on the information that was given today. But I don't think that the board, if it's a ridiculous rule, it is a ridiculous rule put in place by the legislative body of Monroe County. Monroe County commissioners have put this rule in place, and I don't think this board has the authority to deviate it from it. This board hasn't been given the authority, as you read the code, to deviate from the 1 acre. You do have the authority to deviate from the dual field area requirement. It's my understanding that that's not a problem, as the buyer just said, that's not a problem. There is enough space for a dual field area requirement, but there's not 1 acre. And I don't think this board has the authority to deviate from that. I did double check with my boss, who's the head of the legal department and who does a lot of our planning and zoning issues. And, certainly said the county commissioners could always amend Monroe County Code 365-4A to allow for the authority of a board. But this board hasn't been asked to allow for variances from the 1 acre. That may very well be, as the buyer says, a ridiculous rule. Who knows? A lot of counties do have that rule. So if it's ridiculous in a lot of counties in Indiana. But I wouldn't advise this board to make an exception to the 1 acre today, because I don't think you have that authority. And I certainly would want to do a little bit more research to see if it is in fact a grandfathered lot. I also want to make sure you hear from Ryan, if Ryan has now been elevated. Do you know if Jonathan, have you elevated Ryan Casper Cushman? There he is. I see him.
Hello.
Hi, Ryan.
Did anyone have any particular questions for me?
I had one question. Ryan, have you been out to the lot and taken a look yet?
No, I have not.
So is that something that in the, again, he said going out to take a look at the lot, that's not obviously going to change the size of the lot, but if, is that something that you'd be able to do if we were to have a meeting to meet with the buyer and meet with the agents and talk to somebody in planning to see if, we might be able to, again, to figure out a solution to this?
I can of course make arrangements to visit the site.
Mm-hmm.
Ryan, this is Mark on the board. Looking at the 1 acre requirement, is in your mind, is there a good solid rationale for that 1 acre requirement? Or is this something that, once this particular case with this owner is resolved one way or the other, do you feel that there's good scientific reason and rationale for that 1 acre size? Or is this something that maybe should be relooked at?
Well, I'm not sure if I'm really qualified to answer that question on whether, because I certainly was not involved in the decision making. However, if precedent is set to allow septic systems on lots smaller than 1 acre, I think that it may open up the door to some serious problems as you look at small parcels of land, especially up against waterways, in situations where if a septic system does in fact fail, we'll be looking at straight sewage discharges directly into waterways, because we have lots of small parcels, in particular around Lake Lemon. But as far as commenting on the scientific validity of the decision of to have this 1 acre lot size, I don't think I'm qualified to really give an answer to that. I saw the application come to my desk. I had a look at the site itself on paper and on a map, saw no indication that it had been pre-approved as part of a subdivision to utilize septic systems, nor that it had been recorded as a platted lot and did not meet the bare minimum requirements set forth in Monroe County Code. So I denied the application right on the front end.
Thank you, Ryan.
I have a quick question for Ryan, if I might.
All right.
Yeah, Ryan, what were you able to view? I've heard that the information as far as previous septic systems may or may not be available, previous septic requests, sorry. So is it or isn't it available? And can somebody help me understand what that statement meant? Because, you know, are the records available or are they not available? It was kind of a wishy-washy statement there about may or may not be available past the 1970s.
I'm sorry, let me see if I can interpret your question. Are you asking about the access to historical septic records?
Yes, yeah.
There would
That's
be
where it
no
would be
records
located,
of-
right, if there was a request?
Well, okay, so the Monroe County's Health Department was founded in 1965. So there would be no records available about septic systems prior to that date.
Okay.
Our office has no record of a septic permit being issued for this lot.
Okay, and so you're telling me that you have all those records post 1965 available to review?
Anything that was filed, we have, I think it's about 22,000 septic records. I can't tell you I'm not at the building right now, but I can tell you record number 001. I can pull it and tell you what date that was.
Okay.
And we have records available back to that date if they were in fact filed. There are occasions when we found systems that were installed without approval. So we do not have a record of every septic system in Monroe County, but if there was a record filed, we would have access to it.
Okay, thank you. Thank you.
Board members, do I have any type of feeling from you how you want to go with this? Should we make a motion? Should we table? What do you think?
A question, I guess, for Margie. I want to understand that if the owner can come up with a piece of paper that shows that this was platted prior to the code, then this becomes a moot issue. Is that right?
So yeah, let me read from the code for you. So 365-4, the Monroe County Code has 3 sections, A, B, and C. A is the one that we're talking about right now that says, in order to be considered for a private sewage disposal system, a proposed building site, which is a defined term, shall have a minimum acre of 1 acre, or minimum area of 1 acre. Then B is the provision that talks about the variance to the dual field area, and that talks about sort of a little bit more details about the system. C says individual lots in subdivisions designed to utilize on-site sewage disposal systems for which plats were approved by the local plan commission or recorded prior to September 1st, 1993, are exempt from the provisions of 365-4A, provided they meet all the other requirements. So if they meet all the other requirements and they can prove that it was in fact, it's either, there was a plat approved by the local plan commission or recorded prior to September 1st, 1993, then yeah, we'd have they'd be grandfathered. So I have access to the recorder's documents on my computer, but not back. I can't find a 1980 document. So I'd actually have to go pull the record. Ashley Craner knows all about that, as she works for the recorder's office. I don't have a number to I don't have a document number. I was trying to look.
Well, the B280 that he referred to in that book 280, page 365, that sounds like a deed. That doesn't say, that's not, we have plat books and we have plats, but that sounds like a reference to a quitclaim deed or some sort of deed.
Well, and I can show you, if I show you, I was able to pull up the deed from when this
Yeah.
was from 1991. That's book 391 page, if you could see my screen right now, book 391, page 279. I see the warranty deed recorded August 12th of 1991. And here's, this is the legal description, 0.52 acres, subject to all highways and rights of way, subject to an easement in favor of the Morgan County Rural Electric Membership Corp. I don't know if the document that you're referring to is this easement, or if it's an actual plat. And I don't know, Mr. Baker, if you have, any more details about the document that you read from.
Yeah, just the fact that it was, as they stated, that this was a subdivided a portion of said quarter section into 12 lots. That's all I have.
Are you reading from a document that says easement, or what are you reading from?
Yeah, this document, I don't know if you can see it.
It says book 280 or.
They have that information.
But what's it titled at the top?
This says dedication of easement.
Okay.
Okay.
So that's not a plat.
No.
A dedication of an easement is probably what this is referring to here.
I didn't refer to this as a plat.
Yeah.
Said that the legal description of each lot and a plat thereof being attached to this dedication of easement. So.
Yeah, so what you're saying is that easement references a plat.
It does, yes.
Right, sure. And so, if you look, and again, when Ryan and I, and we spent a couple hours, going over this, sort of looking at sort of the history, especially of the ones that the petitioner referenced, and we were sort of trying to figure out, what was what. It appears that some of the, like if you look at the properties on North Tunnel Road, those were platted lots. And it looks like the ones that, especially the vacant lots on North Shore Drive, were not platted lots. They were vacant, unplatted. Again, I think that I had a long conversation with Ms. Everly Polly, who has a long history of living on the lake and knowing the history of her and some other people who've owned property there. It appears that the last, property that had a system of sorts on North Shore was the one right next door to this one. And Ryan, and you correct me if I'm wrong, but it appears that, and I included this in your packet, it appears that house sold recently, that another potential buyer had come in and applied for a septic permit to get a new permit, and never followed through with getting that new septic installed and walked away. And then that property, according to the sales disclosure, sold. It had a house with it, but it sold as is for $55,600 less than the AV. So it was less than the AV. It was $55,600, which was less than the AV. They lowered the price $21,000, and that's probably because there's an older septic system with that house.
Yeah.
I'm sorry, what were you saying, Mr. Baker?
I'm just not sure the relevance to this particular topic.
All I'm saying is that it doesn't appear that there are, it doesn't look like on that string of the lake that there are septic permits or, like that's been developed the way that the other side of the lake has been developed. So they're slightly different. It's sort of maybe comparing apples and oranges a little bit, one side of the lake to the other.
Yeah, I'm just trying to understand what our piece of property has to it, what records are available to support the documentation that I have that a plat was recorded for this piece of property. And so, I mean, beyond that, I mean, at this point, based on your legal description, there's really, other than actually, trying to battle this legally, it seems like the only way out is if this is platted, based on everything you've given me today.
As I said in the report, I mean, the way that other property owners around here, potential buyers, have gone about it is to get an easement on another neighbor's property in order to locate a septic system, or acquiring more than one lot in order to make it a buildable site. Those are certainly two other ways around it. And I tried to address that at the end of the staff recommendation.
I read that. But what you're telling me is that the changes that took place, I don't know when this particular 456 went into effect. Did it go into effect after we purchased the property?
I'd have to look back and see when the last code provision was. I mean, when I know that this chapter was last amended in 18, but I don't know if 365-4 was amended in 18. I'd have to do a little bit more history onto when the codes were changed for that. But I don't know that even if the code changed after you bought it, again, I don't know that your lot would have been affected by that code change or not. A lot depends upon whether it was, whether it was platted or not. My guess is that the code, based on the fact that it has a date of September 1st, 1993 as the grandfather date, my guess is that was when that 1 acre thing was changed, which would have been 2 years after you bought yours. But
I have a motion. I move that the board consider tabling this issue until and unless appropriate documentation shows that the site is able to be fitted with a legal sanitary system. And then we could revisit the question and consider it under the legal stipulations of the code.
We have a motion on the floor. Do I have a second?
I'll second that.
Can that be clarified again? I didn't quite understand the legal.
The motion was,
legal septic system.
well, the motion was to essentially establish whether or not it's possible to have a legal septic system on this site. And then the board can decide whether or not an appropriate kind of sanitary system can be installed or considered. In other words, the documentation is needed, the platting, the history, whatever it takes to show us that there really is a legal basis for acting as a board on this question.
I have a question. I just about the motion too. So, and this is a question for Margie. If we have no legal ability to grant a variance, which is seems like what you're saying, who does? Does anybody?
There is not, according to to this code, there's a hard and fast 1 acre requirement unless you're grandfathered. So there wouldn't be a variance from the 1 acre. The county commissioners, the legislative body of Monroe County, have not provided for the allowance of a septic system currently, if there's not at least 1 acre. Now, again, you can go through, the few examples I went through in my staff report. There was already a system there. They allowed a repair. It was grandfathered, those sorts of situations. as we've seen in this area, there were property owners who had a smaller lot. Does that mean that lot's worthless? No, it just means it's worth less than a 1 acre, but it may be valuable as land to purchase to connect with another lot in order to get to 1 acre. That's very common. We see that happening a lot at Lake Lemon, where property owners from out of county are coming and buying 2 or 3 lots, putting them together and putting a house and a septic in place.
So from a legal standpoint, basically, we can't do it in a variance anyway. And
I don't think the authority to.
And the only body that could change things is if the code were changed by the commissioners. It's despite the wonderful presentation. I mean, I understand why the gentleman,
So
that's not, the thing is, we don't really have the ability to do anything here.
Yeah,
So my question is,
so there's, I don't see the point in considering this at a future date, because we don't have the authority to consider it to start with, it appears.
Unless
Larger lot.
what George is saying is, what if it was platted? What if,
Oh, yeah, well, sure.
There's reference in the easement to a plat. Ryan
the motion that George made is to give the applicant additional time to make certain that there's not documentation, right? I mean, basically we could deny the request for variance today because we don't have any evidence that it meets any criteria to approve a variance. But the motion is to give the applicant additional time. Okay, so otherwise, we could just deny it right now. But I think the fair thing to do is, if there's any lingering questions that the applicant has, is to work that, to try and work that through with the health department or the county attorney.
And I'd be more than happy, as I mentioned, also to AJ Bolin and to Margie Everly Polly, be happy to sit down and talk with people about what is there and sort of what are the options. Again, I want to make sure that the board doesn't think that, I think that tabling is totally appropriate at this point. It gives us a little bit more time to do some additional history work. But there's all kinds of case law on, what's a taking and what's not in Indiana. And, land use regulation doesn't constitute a taking as long as it's tied to a legitimate end, like public health, and doesn't deprive the owner of an economically viable use of the property. We're seeing a lot of cases at Lake Lemon where property that is less than 1 acre is purchased so that it can be connected to another lot and then used as a building site. So there is a value to this lot, whether or not it can have a house and a septic on it. There's still value, because we've seen many situations where these smaller lots are being paid or they're being used as the site for an easement. So there's value there.
Okay,
I would never assume a total taking. I think it's more partial regulatory taking, legal terms, but yeah, I understand.
Well, can I make one final comment, Kay? And,
sure.
I'm just speaking for myself. If we had the power to make a variance, I feel like that the buyer in particular, in his presentation, I'm sorry, I don't know your name, it just says ELM. I feel like you made a convincing argument in this case to have a variance considered. Okay, so I don't know. I mean, unfortunately, that for whatever that's worth at this point, it seems because of the way the code's written that our hands are somewhat tied in this case. But if I were considering a variance and we had that authority, I might be favorably disposed towards your case. So what I'm hoping is that maybe at some point in the future, maybe if it's appropriate, and I'm not this soil science is not my area of expertise. So if it were appropriate to consider a variance on an acre, less than an acre, I think maybe if there's some avenue can be legally developed to that, I would encourage it. But to Ryan's point earlier, the 1 acre thing was put in place for a purpose. And geez, I'm not unsympathetic to this, to Mr. Baker's position when he bought this property. We faced this same problem in 2013 when an older couple brought this. And I mean, it just broke my heart to have to do this because they bought this as part of a retirement plan. But we had to deny it because it was just not a legal, there was no legal avenue for us to grant a variance. And in that particular case, I don't think we would have, but that's my comment. And I just wanted you to know that. So.
Did we have a second on Dr. Hegeman's motion? I kind of heard one
We
from
did, Mark. It was Mark.
Okay.
Yes, we have a motion and we have a second. Are we ready to take a vote? Any other discussion before we take a vote? Okay, let's vote. Cranner,
Yes.
Hegeman,
Yes.
Norrell,
Aye.
Pritchard,
Yes.
Talukian,
Yes.
Wren,
Yes.
and I also vote yes. So basically, the burden of proof is going to be on Mr. Baker to try to find this documentation for the future.
And we're more than happy to help with that documentation. We're right in the courthouse and we can see what we can find in terms of code history and in terms of plat. So Mr. Baker, I would encourage you to reach out to me. I know AJ and Margie both have my contact and we'll work with you to see what we can figure out.
And I'm always there in the office to help too, Margie.
All right.
Okay, thank you.
Okay.
Can I just add one thing? It would be nice if an assessment as to the real soils and whether a Presby system is safe on that lot would be brought in front of the board. Right now, that's completely being ignored.
Thank you for your comment. Let's move on to the old and continuing business. Penny, COVID update.
Sure, I think Amy Meek is still on the call, our public health nurse director, and she will kind of give us an update on that front, and then I will add a few things.
Okay, Amy, are you there? I don't see you right now, but
I'm here.
There you are. I see you now.
Okay,
Go
I just want
ahead.
to give a really quick update. So we have, as of today, have done 65 COVID vaccine outreaches that are outside the walls of our building. Continuing to do, several of those every week. Unfortunately, not a lot of uptake of the vaccine. The homebound program that we've been doing each week has now transitioned over to the Indiana Immunization Coalition. So it still continues, but the coalition took it over for the entire state. And unfortunately, we've also seen a little bit of an uptake of vaccine preventable diseases in some of our school age kids. So of course, we're fearful that that's probably because for a year, they've gotten a little bit behind on vaccinations. The clinic has been very busy with back to school vaccines. So hopefully people are getting in and getting those all caught up. Right now, our biggest plans are for MCCSC and RBB. We will be in all of those schools, September, October, November, doing flu shots and COVID vaccines for those 12 pluses. That's all that I have.
Anybody have questions for Amy? Thanks for all the good work you do, Amy.
Thank you.
Thanks, Amy.
Okay, Penny.
Sure, just a few additional updates. As of today, fully vaccinated, we've got 57.5% of our eligible population. Our lowest group of vaccination is still in that 12 to 19-year-old group. So hopefully those school clinics, the flu and COVID vaccines will help with that, make that easier to access for people. As Amy mentioned, still doing lots of outreach. We did have 2 more deaths occur this weekend. So we have a total of 182 deaths in Monroe County now from COVID-19. Our 7-day average of positive cases is kind of a rolling average, is now up to about 23 per day. We may still be in yellow this week in terms of that advisory, but we're going to be very close to orange. So I do believe that if we can get people to continue to vaccinate, mask, practice all the various layers of prevention, use every tool that we have in our toolbox, that we can curb this. But the Delta variant is definitely much easier to spread. That's really what seems to be what we're seeing in Indiana the most. So in terms of the regulation, we are focused first on education. I've talked with the compliance officers. Our first order of business, if you will, is to make sure that businesses, as they are visiting them and checking to see if they have the signage, what's going on in that business, is to make sure that they understand what the regulation is. So the business, the people coming into the business, the employees at the business, if it's public facing, then they need to be masked. So we want to make sure that people understand that they've gotten the information. If they need signs or some guidance, they have questions, we want to be able to address those before we start to really look at kind of non-compliance. We want to make sure that people know what they need to be complying with. And we always feel that that's the first step for anything, is to make sure that people understand what's going on. Yes.
Denny, did you get a chance at the commissioners meeting to talk about the compliance officers in the contract?
Yes, they did approve it during the work session, and it will be ratified on Wednesday during the regular session. Yes. So they are starting, and again, they've been directed to focus. We've always had them focus on education, but that's really right now our primary goal, is to make sure that people know how to comply, and then we can address any non-compliance. In terms of schools,
Penny, if you would please remind us of the steps of non-compliance. What are the consequences if education doesn't work?
Certainly. So there are, fines are a possibility. We can bring in legal and take other legal actions as well. In some cases for, businesses, could mean closure. That's never a goal that we want. So again, always about working with somebody to get compliance.
But are those steps specified somewhere in terms of the fine structure? Where is that found?
That is part of the Ordinance Violation Bureau. It's in the code in terms of the fines and the level that they can be. Margie probably has that more memorized than I do, but it can be per occurrence, per day for a violation.
Yeah, and I can tell you that, just like a prosecutor of criminal code has professional discretion to address the violation of criminal code, how they deem appropriate. We also, when we enforce civil cases, have professional discretion. So Penny and I had, and her staff worked closely together last year. When we would get a complaint of violation, we would always reach out to to both the complainer and to the business owner and see if we could sort of figure out what the facts were. And once we felt like we had a pretty good understanding of the facts, and sometimes that required us to use the enforcement officers to do a little investigation for us, or sometimes I had to reach out to the police department and see what I could find out from dispatch records or police records to find out and verify, the he said, she said, and figure out what the facts were. But once we felt like we had a pretty good idea of the facts, we would address how do we quickly get in compliance, and how do we get voluntary compliance. If we didn't get pretty much every single time, we were able to get voluntary compliance. We were able to, I remember a situation where a business owner said, no, I don't think it happened that way. And I said, well, I probably will know by about 1 o'clock today how it happened. And so once I was able to get some police reports and some other records, I could figure out what happened, show those records to both sides. We would agree upon what happened and then figure out a solution forward. So there was only one time when we really had to assess fines, and as Penny said, every single day, it's a fine up, I think it's up to $500 per day. Every day can be of continued violation, can be a new fine. I think we had to assess, what did we assess? $2,500 worth of fines to one business owner. And that business owner paid the fines. Had they not paid the fines, then I would file a lawsuit in the circuit court and try to enforce those fines. So, that's how it works. There's not a formulaic approach. Sometimes there's a misunderstanding, and sometimes there's an intentional violation. And we sort of have to figure out which one do we have in our hands, and then how do we feel like it's best to go forward. I can tell you that the business owner that was assessed the $2,500 fine was just philosophically opposed to the ordinance and felt like his customer base would support paying the fine because they were also philosophically opposed.
Penny, when we met last time, we talked about hoping that someone from IU could let us know how the vaccinations were going. Have you communicated with them?
I have, and they will be at your August 23rd meeting. They felt that that was the best time. They would actually have data to be able to share at that time. Yes.
Good.
And we are continuing to work, with the term starting again. We are working with the Office of Student Affairs and the Office of Sorority and Fraternity Life, just to remind them of the recommendations. So we continue to work closely with the university to make sure that students have correct information, understand what's expected of them as well. I know that there's been information in the paper about our area schools. None of the schools have indicated to us directly, to me at this time, that they won't be complying. But we have, the paper has reported that at least one school has said that they won't be. We have had some schools say thank you for the regulation. And so as we continue to get some people certainly who are opposed to the regulations, we have people who are also very much in favor of them. The other thing that I wanted to share, we have a partnership with City Parks Department and IU Health, Positive Link, our harm reduction program for public health and parks. And we received our kind of mid-year update. And so far we've screened 47 individuals over the course of 13 weeks. So those are tests for HIV, for hepatitis C, for syphilis in varying degrees. Not for all 47 people did not get all of those tests, but those were all the various tests that were offered. On average, they see 4 or 5 people that are screened each time that they go, and they're there in the park for about a 2-hour period. We kind of switch back and forth between Switchyard and Seminary Park. And that seems to be working very, very well. So far we're getting good feedback. People seem very comfortable about getting the services in the park. So we're very pleased to be able to offer that. Are there questions? No, the other, concerns is certainly as we talk about schools, if there is any clarification in terms of the regulations or what your expectations for schools are, we can certainly talk about that. Margie and I are just trying to, as we said, gather information, and that's kind of the stage we are in right now with schools.
Yeah, and if I can piggyback on that, you'll remember that what you wrote in and approved for your proposed order was that all schools in Monroe County shall follow CDC, Department of Education, and Department of Health guidelines. Did not say shall follow the county regulations follow those other regulations. Obviously, there was a newspaper article over the weekend that said a local school was going to not comply with local health regulations. Again, as Penny said, we've not been told that. We've not had anybody from that school reach out to us. I have called the attorney that was mentioned in that article, Terry English. I've also reached out to Tim Zebarth, who is the representative that the Department of Education told me to contact. He is with Grace College, who's the authorizing agency for that local charter school, so that I can better understand their position.
Which school is it, Margie? If you don't mind my asking.
Yeah,
I didn't
it's
see the article.
it's Seven Oaks Charter School in Ellisville. That's going to open on Wednesday, as I understand. Is that right, Penny? And
That's the way
Terry,
I understand it.
Terry English is the local attorney. He was quoted in a newspaper article. I've placed a call to him just to say, hey, I want to understand, what your position is. I myself, have often said things in meetings, and then when I read about it publicly, it's not exactly what was said or what I meant in a meeting. So I wanted to make sure that I understood what Mr. English's position was. And then I've also reached out to, again, to Tim Zebarth, who's with Grace College, who's the authorizing agency for that charter school. It's my understanding from talking to the Department of Education today that that school is not a religiously affiliated school. They have a classical education platform. So I'm not sure what their position is exactly. I will tell you though, if I can share my screen again. Here's a code provision in Indiana that says the following statutes and rules and guidelines adopted under the following statutes apply to a charter school. And I've highlighted the ones that are relevant. Indiana Code 202656, subject to laws requiring regulation by state agencies. And if you pull that for you to see, all powers delegated to the governing body of a school corporation under this section, and this is a provision that's applicable to charter schools. It says that they're subject to all laws subjecting the school corporation to regulation by a state agency, including Secretary of Ed, State Board of Accounts, State Police Department, Fire Prevention, Building Safety, Department of Local Government Finance, Environmental Rules Board, State School Bus Committee, State Department of Health, and this is the part in red that I highlighted for you, and any local governmental agency to which the state has been delegated a specific authority in matters other than educational and other than finance, including Plan Commission, Zoning Board, and boards concerned with health and safety. That would include the Board of Health. Again, we did not specify in this order that all of those schools had to follow this mask mandate. We did say follow CDC, follow State Board of Health, and follow State Department of Education guidelines. Questions on that?
Don't think so.
If you think of anything, don't hesitate to reach out to me and Penny. We are on a practically a direct line these days.
Okay, Penny, anything else on COVID? Then we're down to budget.
Well, just one comment. As you have probably figured out, this is actually a pandemic of the unvaccinated now, because 99%, more than 99% of the hospitalizations, ICU admissions, and deaths are in the unvaccinated. So while you can carry the vaccinated can carry the virus in their nose and can be infectious, it's been pretty well determined. Certainly, it's in their nose, can be. And you can get sick, but in particular if you're immunocompromised. But generally speaking, if you've been vaccinated, you're pretty safe. So you can take solace in that bit of information. And certainly we need to consider that when we make rules that, because of a few that are affecting the many, I don't think it's fair at all for people not to be vaccinated, not to choose to be vaccinated, but I don't make those rules. So that's kind of where we are. You're safe if you've been vaccinated, pretty safe. Although you still can have it in your nose and probably transmit it. So keep your immune system up. Stay away from those sick people. And I have no idea what they're doing down at the border right now in the middle of the COVID thing. That, my gosh, I just heard that it's 20% now of those people that are coming across the border are positive, and they only check the ones that have symptoms. Now that's kind of scary to me. I don't know how you feel about that, but that's pretty scary. And they ship these people out to various places, and I would have no idea what to do if Monroe County was sitting on the Mexican border. It's just, I mean, it's scary what those people are going through down there. But anyway. Oh,
Thanks.
I might add, Penny and I collaborate frequently on everything, virtually everything. She covers issues extremely well. I don't like to be redundant and just put in my wear your mask stuff and keep your distance, because it's covered so well in so many places. But Penny has a great understanding of what's going on. She expresses the ideas extremely well, as you know. So anyway, I'm always available for phone calls and from the board, or public should go through the health department, of course. But anytime you want to discuss any subject, you're welcome to give me a call.
Thanks, Dr. Sharp. We always appreciate your input. And keep us updated if you hear anything new about the Delta variant. Penny, are we ready for budget?
We are. I don't have a lot. I am going to try to share my screen real well, and you know that I am a little challenged when it comes to that. So we'll, all right. If Jonathan can help me do that, then.
You're ready to share.
All right, there we go. Great. Thank you, Jonathan. So there were a couple things I just wanted to note from the previous board meeting. You had asked us to just put in the 40 hours a week. That was a discussion. So that is in there just for comparison. Obviously, that is a county council decision. It is not a Board of Health decision, but that amount of money is in there. It's 1 year, I think it would amount to about $140,000, I think, somewhere in that range. Salary wise, of course, benefits, salaries always change, so those numbers always go up. So just wanted you to know that we did ask council to put that in there so that you could see it. And council can see it and include that in their discussions. Then the other changes, hold on. All right, okay. I've gotten lost, hold on. Great. Okay. Now I am way off kilter. Okay, hold on. Oh. Well, I'm going to keep working on this, so bear with me. But while I'm doing that, I'm going to kind of try to keep talking at the same time. I'm looking at my, oh, there I go. Think. Yay. All right. Okay, thanks for your patience. As we go down through here, some of the additional changes that we had, and that's why it's just not moving me very well. Okay, There were just a couple other changes that we actually made. One in the health fund, we talked about the equipment line. So we did go to the commissioner's administrator, ask about capital expenses, and the just right now is that we are to put those in our budget, but also we will fill out a capital request form and go through it from that process. So we did add $3,300 in capital expenses. It's not a lot, but we went through kind of our wish list, if you will, for things that would fall under capital. Usually things like computers and things like that, we may have those requests, but that's usually done through tech services and their budget and not ours. So that was a change. The other change came to the local health maintenance fund and adding, increasing that a little bit to $5,500 to be sure that we could cover some new binders for our birth and death records. And we had talked about this last year, the binders that we were, actually we got a sample of, and when we really got them, they don't do the job. They hold about half of what we need them to hold, and they were going to take up a whole lot more room. So we believe that we have found a good replacement that's actually cheaper. So I did put that in this budget as well. So again, using a little bit more carryover. The third thing I just want to note, and I'm sure that we talked about this, but just for clarity, the trust account does have staffing in it. We do use carryover money. And if the county council decides to, for instance, increase salary, increase benefit cost of some sort, then that would go up, and the plan would just be to increase the amount of carryover that we request. So we wouldn't lower the supplies or travel or any of those other lines. We would just increase that request for our trust account. And the trust account and the local health maintenance fund requests to the state are due at the end of September. So that will give us a little bit of time. We'll know what council is looking at, if they're thinking that there'll be a change or not. So we'll have a little bit of time to make any adjustments. So I just wanted to share that. And I guess it would be helpful to get overall approval for those changes unless there's something else that you want. This is due to council later this week. So you have an opportunity to make changes if you would like to.
Board members, do I hear any motions regarding the changes that were brought forth?
I would move that we accept the changes that Penny has proposed on the budget.
I'll second that. Oh, go ahead. Got it. You beat me, Carol.
We have a motion and a second. We'll do a roll call. Cranner?
Yes.
Hegeman?
Yes.
Norrell?
Yes.
Pritchard?
Yes.
Talukian?
Yes.
Wren?
Yes.
And I'll vote yes. Those changes are approved, Penny.
Thank you. And I think that's all I have.
Okay. Board member comments. Anything you want to comment on? Well, one thing we need to look at is when we have our next meeting. We said we were going to be meeting every 2 weeks. And if we go 2 weeks from today.
Oh, yeah.
Didn't we already set up a meeting?
Yeah, we did.
Yeah,
I think we set it for the 23rd. I think it's
yeah, we have one on the
23rd.
23rd set up already.
We're all
3
set.
p.m.
We did have one question. I did have one question. I wanted to know why on my Board of Health meeting tonight, I had sing happy birthday to Margie. Margie, is it
Margie,
your
is
birthday?
it your
Yeah, happy
birthday?
birthday. Yeah, let me show you. My husband put a little sign up. Can you see it right there?
Ah,
Happy
to you.
Yeah.
Well, happy birthday, Margie.
Happy birthday, Margie.
I'm gonna have some cake just as soon as we're done.
You deserve an extra piece, babe.
Thank you. I'll have
You
that.
really do.
Thank you. Thanks very much. I can't think of a better group to spend my birthday with, so thanks very much.
Aw,
And
shucks.
Mr. Baker, I see you're still on here. Please do reach out to me and we'll see if we can figure out a solution to your problem.
Anybody else have any other comments, anything? Then I will see you on the 23rd.
Sounds
Thank
good. You guys have a
you.
great evening.
Yes,
you.
ma'am.
Yeah,
you guys.
bye-bye. Bye.